Let us recap and say the circumstances where bail can be granted by the police. Right? If the matter is not classified as being in Part 2 or Part 3 of Schedule 2 offences, then bail can be granted by the police at the police station by a police officer with a rank of a commissioned officer. If it's a non-commissioned officer, he cannot grant bail. It has to be a commissioned officer, right? In terms of Section 59 of the Criminal Procedure Act, right? And then we come to the circumstances where bail is granted by a prosecutor. Section 59, capital A of the Criminal Procedure Act provides that a prosecutor may authorize the release of an accused on bail for offences listed in Schedule 7 of the Criminal Procedure Act. The prosecutor can only do so if authorized thereto by the Director of Public Prosecution, right? Most DPPs have given blanket authorization, and also after consultation with the investigating officer. It is important that you consult with the investigating officer. The granting of bail by a prosecutor can be made subject to certain conditions, right? As with police bail, such an application can only be dealt with prior to an accused's first appearance in court. The prosecutor's bail stands until the first court day, and a court is empowered to either extend bail or, if it deems fit or it deems it inappropriate, to do so, to consider the application for bail by the accused. So, meaning a prosecutor can grant bail and then before the first appearance, but the court has the powers to say, I think something did not go according to what is required, to all the requirements. So we need to reapply for bail. Then the accused will apply for bail. And also, let's come to a situation where bail is not granted by the prosecutor or the police, that is not the police bail, which was the one that is granted by the commissioned officer. The various offences which are referred to in Part 2 and Part 3 of Schedule 2 of the Criminal Procedure include, inter alia, possession of or dealing in dangerous or producing drugs, murder, rape, robbery, and assault when a dangerous wound has been inflicted. And are offences in respect of which a police official may not grant bail. Persons in custody for allegedly having committed any of such offences can possibly be granted bail by a prosecutor if the offence is listed under Schedule 7. It has to be listed under Schedule 7. Any other insistence will have to be referred to court. For the latest offences created in terms of the Criminal Matters Amendment Act 18 of 2015, involving the violation of essential infrastructure, that we must look at Section 2 of that Act, which places the prohibitions of police bail and prosecutorial bail for offences involving ferrous and non-ferrous metal, which form part of the essential infrastructure. That is, now those are cases where you will see people going around carrying what we call scrap metals. They will go to, maybe they go to a building, government building, and take all the metal roofs, cut it and go and sell it as scraps. There is a new law that prohibits that, has declared that a crime. So it's a serious crime. You cannot get bail if you are found to have done that. So bail in those instances can be brought in court as provided for in Section 60 of the Criminal Procedure Act. So here, Criminal Procedure Act, the Section 60 of the Criminal Procedure will come into effect. So you will go and do a formal, what is called a formal bail application. Right. And then this comes to something called the burden of proof. Now, who bears the onus of proof in a bail application? That is the question. And the person, prior to the commencement date of the interim constitution in 1994, the burden of proof of all bail applications was on the accused to show on a balance of probabilities that the application should be granted. You can refer to the case of Hudson. Citation is 1980, volume 4, SA at 145. Seat of the court is N. In terms of section 35, subsection 1 of the 1996 Constitution, that is Act 108 of 1996 Constitution, an accused that is now a detained person has the right to be released from detention if the interest of justice permits, subject to reasonable conditions. Right. It was therefore clear that the state had to convince the court that the interest of justice indeed required that the accused be kept in custody. That is now, if you wrote Haggard and another versus the District Magistrate Johannesburg and others, volume 1, 1994, and volume 2, SACR at page 304. Seat of the case is W, that is now Witwatersrand. And also you can look at Makano and another versus District Magistrate Johannesburg and others, volume 2, 1994, and also volume 2, SACR, page 307. Also the same seat of the court, the Witwatersrand. So you need to know what is the meaning of SACR. Last year I had students, when I asked them what does SACR mean, they don't know. So when you come to class on the next occasion, you must come and tell me what SACR stands for, and you must also tell me what BCLR stands for. Right. So this did not necessarily mean that the state now carried a burden to prove that the accused should not be released on bail. In fact, in Procureur General van die Witwatersrand Plaaslike Afdeling versus Van Heerden and Annere. So that is now the Prosecutor General, the DPA of Transvaal, and Plaaslike Afdeling, that is the lower division, versus Van Heerden and others, 1994, volume 2, SACR at page 469, and Elish and others versus the NPA, the Prosecutor General, at WPA 1994, volume 2, SACR 577, at also Witwatersrand. It was held that there should not be any onus in bail application. The only purpose of a burden is to enable the court to make a finding at the end of the hearing as to whether the accused should be released or not. So this case said there should be no onus on anybody to prove anything. It's only the court that has to decide. So this view was enforced with the enactment of the Criminal Procedure Amendment Act in 1995, that is now Act 75 of 1995, which amended various sections pertaining to bail application. We can also see section 50, subsection 6, and section 60, subsection 2, and also section 60, subsection 3, which sections have been further amended by the latest Amendment Act of 1997. In 1995, section 60, subsection 11, reintroduced an onus on an accused in certain circumstances, namely when he or she was either charged with a Schedule 5 offense, or when he or she was charged with having committed a Schedule 1 offense whilst on bail for a Schedule 1 offense. See a case of Dlamini, 1997, subsection 1, SACR 54, and also Mbele and another in 1996. The citation is 1996, volume 1, SACR at page 212. And also see Fermas, 1996, subsection, volume 1, SACR at page 528. The seat of the court is T. And Stanfield at the citation is 1997, volume 1, SSR at page 221. C in brackets, that's the seat of the court. And also the 1997 Amendment Act retains the reverse honors clause and goes further. Section 60, subsection 11 is now split in two. In regards to the new Schedule 6 offense, not only are such applicants required to be heard by the court, which does not mean a regional court, save where the DPP so directs in writing, but an accused is required to adduce evidence to certify the court that exceptional circumstances do exist which permit his release. Right? So now, with the new amendment, it has transpired that it is the onus is on the accused, that is now the applicant in this case, because in the bail application we've got, we don't have an accused, we've got an applicant and a respondent. The accused now becomes the applicant, and the public prosecutor or the state is the respondent. So the onus is on the respondent to prove on a balance of probabilities that circumstances do permit his release on bail. So you need to be very careful. The schedules are important. You don't go to court and just say, you must know your schedules. Schedule 7, Schedule 2, be careful. Murder can be Schedule 2, and it can also be Schedule 6. So you need to differentiate as to when does murder become Schedule 6 and when does it become Schedule 2. So be careful. It can be Schedule 5 as well. Schedule 5 or Schedule 6. So you need to be aware of your schedules. Let's come to the elephant in the room. The elephant in the room is the issue of exceptional circumstances. What are exceptional circumstances, right? Because this is a requirement that in all Schedule 6 offenses, in terms of Section 60, subsection 11 of the Criminal Procedure Act, exceptional circumstances must be established in order for the court to release the applicant on bail. So the problem that we have is that we know that the onus is on the accused or the applicant to prove that exceptional circumstances, as completed by the section, Section 60, subsection 1 of the criminal, exist. Right? This was confirmed in the case of State versus Mabena and another. This is the citation will be 2007, volume 1, SACR at page 482. This is a Supreme Court of Appeal case, right? So it's a case that you can cite when dealing with exceptional circumstances. The court also held that a proper judicial inquiry is to be held to determine whether provisions of the Criminal Procedure Act have been met, and issued an order that the granting of bail be set aside as nullity where it was not done. So if this is not done, then the court decided that the granting of bail should be set aside. Right. Now, here we go. The legislature has, however, not defined the term exceptional circumstances. the law, the legislature just said, now for a change, exceptional circumstances must exist for anyone to be released on bail. But it did not define what is it. What do we mean by exceptional circumstances? Is there a list of exceptional circumstances? No, there is nothing. It differs from case. It differs from case to case. Even the Constitutional Court attempted to define the term. Judge Gleicher stated in the case of State versus Dlamini, and also in the case of State versus Dladla and others, and also in the case of State versus Joubert, and also in the case of State versus Skittekat. This is in 1999. The citation will be 1999, volume 2, SACR at page 51. It's a Constitutional Court judgment. Everybody has got to go and look at that to say, what does the Constitutional Court say about exceptional circumstances, right? At page, you must look at page 75 and page 76, that the term is not so vague that an application for bail does not know what the person making the application for bail does not know what is meant by this requirement. Okay, so an applicant is given a broad scope to establish the requisite circumstances, whether they relate to the nature of the crime, the personal circumstances of the applicant, or anything else that is particularly cogent. Judge Gleicher goes on to say that exceptional circumstances are not necessarily extraordinary. So it mustn't be extraordinary circumstances, right? And he gave an example that one can establish the requirement by proving that there are exceptional circumstances relating to his or her emotional condition, something like health and his state of mind, the circumstances. Sometimes some people will go to court and say, because I have a child that needs special care or special needs, or that goes to a special school, that could be exceptional circumstances, where you've got a child that is disabled that needs your care 24 hours. That could be exceptional circumstances. So it will differ from case to case. You cannot use those circumstances and say the court must release this applicant because in a certain case a person was allowed was released on bail because his child was disabled. No, it may not. That argument may not stand. So that is why Judge Gleicher said it will differ from case. It will differ from case to case, right? In interpreting circumstances, our courts have stated that courts should take into account the following factors. Words of legislature ought to be given to list onerous interpretation when imposing a burden upon an individual. Also, the constitutional values, including the right to freedom, presumptions of innocence until proven otherwise, and a right to be released on bail if the interests of justice permit, need to be considered. The case that you can support your arguments with State versus C, 1998, volume 2, SACR at page 722, and also at page 724. The seat of the court is C. That is now the Northern Cape Court, right? When defining exceptional circumstances, bear in mind that every case must be measured on its own merits. What may be applicable in one case does not entail that it should also simply apply in another case. see also the case of S versus Porten. Porten is Porthen, Porten and others. Citation is 2004, volume 2, SACR at page 242. The seat of the court is C in brackets, and also see at page of the same case, see page 248. It is a value judgment that court has to make. That is now when dealing with exceptional circumstances. Right. Okay, let's stop there for now, because I think you can also read and see what does it say about exceptional circumstances.